Former President Donald Trump is attending the beginning of a New York State civil fraud trial against his family-owned businesses. New York State Attorney General Letitia James claims that the Trump Organization repeatedly committed fraud on financial statements, all in order to secure business loans and insurance policies. Trump dismissed the case as a witch hunt and called the AG a racist.
Jessica Levinson joins us now. She's a CBS News legal contributor and a professor at Loyola Law School in California, always explaining the law and the thinking of the Supreme Court. So the judge, Jessica, presiding over this case, already found Trump and others liable for fraud last week. Why was this ruling delivered before, and how can it impact
this is so confusing
whole
to me.
Trial? Because no jury. There's a judge. He's there voluntarily. There's already a ruling.
He's on camera today looking very smiley and goofy with his gray hair. This is all very unusual. So he says stuff before he heard the arguments based on the paper documents? Please explain. I'll butt out of it. Sorry.
No, these are great questions. And it is confusing. And in fact, the former president's trial team said, Your Honor, no offense, but could you tell us exactly what this trial looks like? Essentially acknowledging that he had already found that Trump and Trump organizations had engaged in fraud. Now, I know this sounds strange, but it's actually not unusual if the trial proceeds as I think it will, which is that there was already a finding of liability, either in whole or in part. And now the rest of the trial will be about the amount of damages and the remedies. Now, this is a bench trial.
Sorry, it's a little bit distracting.
We're seeing the video of the judge.
Just smiling and taking off his glasses.
It's like a family reunion shot. It's very strange footage from inside a courtroom. First of all, we're not used to seeing Donald Trump at a table in a courtroom flanked by lawyers. Letitia James is there in the background. His son is over his other shoulder. These pictures are just very... I don't believe we've seen them before. Correct me if I'm wrong.
We haven't seen this before. And what will be really interesting is, of course, the former president is facing other cases. This is a civil fraud case. He's also facing criminal cases. It'll be really interesting to see how he comports himself in the Georgia criminal case, because that's the only criminal case that will be televised. This is our first insight into how he comports himself in a courtroom during a full trial. As you said, a confusing one, but a trial that is essentially based on how much money is he going to have to pay, and will he have to stop doing business either entirely or in part in New York.
So, Jessica, let's talk a little bit about what Donald Trump's legal team is arguing. And I'm reminded as I recount their argument, which I'll do in a second, when Donald Trump was asked in the 2016 campaign about not paying taxes, he said that makes me smart. Paying as little as possible, even maybe skirting the law. And in this case, you've got his legal team arguing that the fact that he overvalued certain things is proof that he's a, quote, genius. And then secondly, in the court of public opinion, the argument that this is a victimless crime. The banks got paid, the insurance companies got paid.
The Trump Organization got paid.
Everybody's doing fine on this. So there's no victim. And being clever with your paperwork and getting a better deal makes you smart in business, not a criminal or not a civil fraudster. That's their argument. What do you make of that?
So it's interesting because the attorney general, that was almost the first thing they argued. They said, this is not a victimless crime. So a couple of responses. One, there is a big difference between using legal loopholes, between pushing the limit, between trying to pay as little as you possibly can in taxes in a legal way and crossing that line and actually committing tax evasion or defrauding a bank or defrauding a loan company. And so I know that what the former president is trying to argue is, I'm just a genius. Again, a difference between legally exploiting loopholes and crossing that line over into civil liability. The other thing is, I think that this is kind of common in white collar cases where people feel like, well, who was actually hurt? Nobody was beaten. Nobody was murdered. Nobody was directly burglarized. And I think the answer is, people actually were burglarized in a different way. And that when people do actually commit civil fraud, that there is an impact, and that we all pay, for instance, higher bank fees. We all pay our insurance companies higher fees, that we all pay when it comes to tax evasion, that we have to absorb the money that somebody else gained by ill-gotten gains, and that ends up, again, not as direct as actually punching somebody in the face, but it ends up hurting people in a direct way.
That's a great point. Jessica, I want to switch gears real quick. The Supreme Court today denied John Eastman's effort to appeal a ruling that had allowed the January 6th House Select Committee to access his emails. But the headline here was that Justice Clarence Thomas recused himself. Talk to us about the significance of that.
So I think that actually this makes all the sense in the world. John Eastman is Clarence Thomas's former law clerk. That's a very close relationship. I had the honor of clerking for a federal judge, and that is a situation where I think it makes all the sense in the world for a justice or judge to say, I'm not weighing in on this particular decision. Now, the broader question when it comes to Clarence Thomas has always been, are there other situations in which he should recuse? But this one, I will say, I think it is not a close call. I think he made the right decision. And I think many federal judges, with respect to their former clerks, would make exactly the same decision.
I see. So not an indication that there's going to be more of those recusals. Jessica, thank you so much.
Thank you.